This is a new scam. A text from a number that I don't know. Dad, can you text my new phone number? My phone's broke.
That is a new.
That's a new scam.
That's a new one.
That's ballsy.
Yeah. Well, she said bold. I thought that's bold.
Bold,
Bold.
yeah.
Bold.
Thank you, ma'am.
Hello. Hello, how are you? We are live. Yes, we are. The mics are hot. So, just so you're aware.
How are you, dear? Okay, how are you? Good.
We should only have 5.
Yeah, this time.
Because we only have 6, and Scott is out.
Right, okay, so that.
And then Tanisha's going to be by phone, so we'll only need 4 spots.
Okay. Let me have a page one. If I lose it, I know where I can make it over.
The shotgun is on this piece. I'm not seeing anything move on the camera. I'm one. No, the shotgun is on camera too.
Josh, would you like the agenda?
You want me to unplug the shotgun?
Yeah, the other side, yeah, this middle one.
Sure, we have you in the meeting. The meeting has not started yet, but our camera and our microphone are live, so they are.
This is okay. This is just right. Okay. Seriously, where'd everybody go?
Child's mother. Yes.
Well, Chair, it's up to you. You have a quorum.
Okay. Did Joel, you hear from him?
He said he was going to be here when we did
Okay.
the roll call last week.
Okay.
So it's up to you, Chair. How you want to go?
I think we'll go ahead and get started since, people's time is valuable. And I believe in
Is it giving you some feedback?
Is it good now? Okay. All right. Good afternoon and welcome to our May meeting of the Civilian Review and Accountability Board. We are delighted that you took time this afternoon to share in this meeting with us. And so it is 3:04 and I call our meeting to order. You have before you the agenda. Are there any additions, corrections, questions? Okay, then we will accept the agenda as it is printed. We also have before us, we should have from our April 22nd gathering, the minutes of our March 25th meeting, and you received today the note regarding our April 22nd, 2025 meeting. Is there any discussion? Okay. Having had time to review the minutes from the March 25th, 2025 meeting, as well as a note from our April 22nd meeting. Having had time to consider those minutes without objection, then we move for the passage or the adoption of those notes. All those in favor? Aye. Aye. Can you hear us on the phone? Hello, can you hear us? If you'll unmute yourself so we can hear you. Tanisha, are you there? Okay, I'm not getting a response from her. So, but we declare that the minutes from our March and April notes are referred to the record with thanks. Okay? Do we have anybody signed up for public comment? Okay, we don't have anyone signed up for public comment, so we'll move through our agenda. And so it is my pleasure now to turn this portion of our meeting over to Inspector General Harness. So if you will share with us.
Well, good afternoon.
Good afternoon.
I won't say that. I don't want to make any assumptions. So, the Department of Justice filed a motion to dismiss the civil action against the Louisville Metro government and LMPD. As of this morning, when I checked the court's docket, that motion had not been signed as yet. There was a status conference on Friday with the attorneys. But given the fact that the mayor has said that they're not going to object to the motion to dismiss, the case is going to be dismissed. So there will be no federal enforcement of a consent decree. Upon the filing of that motion, the mayor and the chief of police held a press conference to announce community commitment, which is Louisville's consent decree. I provided you a copy of that consent decree electronically. And it is an agreement between the mayor and the chief as to how they're going to operate under this consent decree. For the most part, it is the negotiated agreement between the Department of Justice and Louisville Metro government. There are some slight changes in some wording of a few paragraphs. How all of that plays out is yet to be determined. There are still a lot of balls in the air, so to speak, as to how all of this is going to come together and how all the pieces are going to fit. So I'll try to encapsulate it for everyone. The mayor is going to initiate and appoint a new community safety commission. He held a press conference regarding the formation of that commission. I believe the leader of that commission is going to be the Director of Public Safety. I'm not sure if that's exactly her title, but her name is Mickey Wright. She came over from the U.S. Attorney's Office out of Chicago. She's been on the mayor's staff for a couple of months. I met with her when she first got here, and we're scheduled to meet again this coming Friday to discuss what we're going to talk about as far as the consent decree goes. So there's going to be a formation of a community safety commission, which will not oversee, but will be reported to by the monitor. The monitor is still going to be a portion of this consent decree. So the mayor has pledged that the selection of the monitor will be a public process. There will be community input. There will be an RFP that goes out. I don't know if they will continue the RFP that went out as the original civil action was filed, or if they'll issue a new RFP. They may have to do that because the budget for the monitor as proposed under the DOJ was $1.4 million. The consent decree budget for the monitor is $750,000. The mayor believes that they have built efficiencies into the system that would allow for the saving of those monies for the appointment of the monitor. So the monitor is going to be selected. There's no time frame for when the Community Safety Commission is going to be formed and who is going to be on it. The monitor will be selected, and then within 2 months of the monitor selection, the monitor will submit a plan outlining 12 months of implementation for the consent decree. That implementation will be negotiated between the monitor and LMPD and Louisville Metro government. Once that is in place, then the monitor will begin their work, and the monitor will issue semi-annual reports, and that monitor will report to the Community Safety Commission. And the monitor will report on compliance levels. The first level is the policy, the second level is the training, and the third level is the auditing and the actual functioning under those changes. And those are outlined in the consent decree. What the policy review should look like, what the training review should look like, and how the audits are to take place. The monitor will report to the Safety Commission. If there are disputes regarding the monitor's report or implementation or changes within the consent decree, there is a dispute resolution segment within the consent decree that allows for a mediator to come in and mediate the dispute between the monitor and Louisville Metro Government and LMPD. After 2.5 years, the monitor is to produce a wide-reaching overall assessment of the performance of LMPD. It's a progress report to determine whether or not it's feasible that at the end of the 5 years of this plan, which it's pretty static that this is going to be a 5-year plan, how they are doing. There is some room to say that it can be extended, but that would have to be with the agreement of all the parties. So right now the consent decree is to last 5 years, unless the department achieves compliance sooner. So that's the overall general version of the consent decree. Within the consent decree, there are specific paragraphs that pertain to us, the Office of Inspector General and the Civilian Review and Accountability Board. Those paragraphs are verbatim from the negotiated DOJ consent decree. So they include certain provisions that strengthen our position as opposed to what's in the ordinance, the founding ordinance. So there's a requirement that whenever a recommendation from our office or the board goes to the chief has 45 days to respond to that. Additionally, there is a requirement that all civilian complaints, whether they're investigated by our office or by PSU, that those complaints have to come to our office for a review. Also, there's a reporting requirement that every 2 weeks that the PSU must update the Office of Inspector General on the progress of their investigations. Also, as it relates to the budget, the provisions provide that we are to have an independent source of revenue. It does not outline how that's to be determined. And it also outlines that we are to have all of our unspent funds accumulate in our own rainy day fund until we reach 1 year's level of operational budget. So that would give us essentially 2 years of budget. We'd have 1 year budget of rainy day fund in case something were to happen where there was a great need for us to expand the staff, contract out, if there was some event that might take place in the public that would dictate that. So that's protected right now. So in the the new budget is going to be finalized this week. So it will be FY 27 that these new budget provisions will have to go into place. I will advocate that we adopt a full, transparent, and independent funding at a percentage of the police budget. That's best practices for oversight entities so that it insulates the independent oversight agency from the political whims of the elected leaders. But that will be a debate to take place for fiscal year 2027. There's also there's now a different categorization for the types of complaints that we will look at and we will investigate. And they're categorized as formal and informal, and that's based upon the consent decree. And what we have decided internally how to operate is that in the past, we would have complaints that would come to the ombudsman, and we would just directly take them to PSU. What we're going to do now is every complaint that comes into us as a civilian complaint, we are going to do the initial intake of that. And then we will determine whether or not to take it to PSU. Part of those determinations are the wishes of the complainant. If the complainant wishes that there to be officer discipline related to the investigation, then the investigation must be done by the PSU. If the complainant wishes to stay confidential, then there would not be discipline related to our investigation, but we would be able to protect the confidentiality of the complainant, and the department would not be able to prohibit us from doing the investigation because of no information related to the complainant going to the department, such as with in the past where we've had to give a complaint and a complainant in order to get certain records. The department will have to give us those records now, and we are, at our discretion, allowed to protect that confidentiality, and the department cannot force us to reveal the identities of those complainants. Beyond that, the non-formal investigations or the non-complaint investigations are what's in the ordinance that we have now, which is essentially a review of the practices of the department, and we maintain the ability to do that. So with all of those provisions, we will operate as we have under the ordinance. So if it's a complaint that is ripe for our office to do, we will bring it to the board for a recommendation. And once the board recommends that the full investigation take place, that triggers the obligation on behalf of the department to cooperate. If it's something that goes directly to PSU, then PSU will do the investigation, but the file and the completed investigation has to come back to us for a review to maintain the public integrity and transparency that the investigation was done fully and up to standard. So there's a level of protection there as well. And so from the standpoint of the consent decree, I think that's pretty much the update. Do you have any questions?
Any questions? I have a question. You say there would be two different kinds of complaints, formal and informal.
Mm-hmm.
So how is that determined? We will determine what's informal and formal, or will it be?
The formality breaks down to the complaint itself and whether it's a sworn complaint. If it's a sworn complaint, then that makes it formal. And then the informal complaint could be a non-complaint that we would do, or an informal complaint could be from an anonymous complainant or a complainant that wishes to remain confidential.
I just want to add that this is a very detailed document, and so as board members, I would suggest that we take the time to really go through it and specifically pay attention to those sections and paragraphs that pertain to us, because it is. And I thank you, Inspector General, for the overview. It was a good overview.
Certainly, yeah. There is a lot there.
It's a lot.
I still go back to it every day, trying to look at different sections to see what I might have missed, what I might have glossed over. That brings up one other aspect. During the monitoring period, the monitor has the ability to refer an act or a complainant to the Office of Inspector General for us to do an investigation. And that can also remain confidential as well. That is in the consent decree. So the monitor would have the Office of Inspector General as an outlet to conduct an investigation, because the monitor will not do individual investigations. And as we go forward, there will be a lot of questions like that. Well, why isn't the monitor looking at my case? The monitor is here to look at things in a broad spectrum and call balls and strikes. Was there a policy change? Have the officers been trained on that policy, and are they acting in accordance with that training? That's what the monitor is going to review. They're not going to look at individual cases. If something like that comes to the monitor, they can refer it to us, they can refer it to PSU, they can refer it to PIU, and that's in accordance with the consent decree.
They're mainly looking at compliance to policy in a sense?
Yes, they're looking at the big picture. They're calling the balls and strikes. Yes, there's a new policy. Yes, that policy is a good policy and best practices. There are provisions that allow the monitor to act as a subject matter expert and advise the department. However, it's voluntary that the department take the monitor's advice. Mm-hmm. It's not mandatory.
Okay. Anything else? We're good? All right.
All right. So subsection for the consent decree update, we have item 1, which is the Office of Inspector General's notice to the Civilian Review and Accountability Board that we are initiating 3 evaluations or investigations under section 36.84 paragraph B. This notice is what will trigger the department's obligation to cooperate with our investigation. And we've decided to look into 3 areas that are in the consent decree. The point of demarcation is we're going to start our review or our evaluation at the date of the findings letter that was issued by the Department of Justice. That's going to be our starting point. And we're going to be looking at 3 areas. We're going to be looking at use of force. The second area we're going to look at is residential search warrant applications and executions. And the third area is street enforcement, fair and impartial enforcement. The first phase of this evaluation is going to be policy. There have been many proclamations about the changes that have been made regarding the department and their policies and their reforms. So from the date of the findings letter to present, we're going to, the first phase, look at the policies related to these 3 particular issues. Any questions regarding those?
What type of timeline are you guys looking for?
Our goal to have the policy review done is to have something to you by the July meeting.
Good. Thank you.
Next on the agenda would be the 2025 first quarter report. We provided a copy to you of that report from January 2025 through March of 2025. This is our obligation under the ordinance to report to the Metro Council. So I would ask that unless you have some changes that you need us to make, I would ask that you adopt the report so I can submit it to Metro Council.
have before you our first quarterly, this is first quarter report for 2025 from our Inspector General. And so you've had time to consider and review the report. So without objection, I move that we adopt the report so that it might be forwarded on to the council.
Can I ask a question?
Yes.
I want to make sure that I'm reading it right for the first quarter. So, of all of the investigations, only one was authorized out of, I don't know, 10, something like that. But, and then on the investigation findings, there was only one out of, which the OIG did not concur with LMPD.
Correct.
Okay. It's I'm not reading into that at all. I just want to make, so, all right, I just wanted to make sure I had my
Okay.
summarization right, yeah.
Any other concerns?
Did we have to provide any, do you know any updates about the board trainings for at least police-wise? I just saw that, I remembered.
Let me make a note, and we can do that under the other business,
Okay. Thank you.
because we have a related item for that as well.
Okay. Any other concerns regarding the report? Then all those in favor of adopting, this report, say aye.
Aye.
Aye. And so we have adopted the report so that you can
Thank you.
pass it on. Thank you.
Item C, under discussion and possible action, is MOU between the Office of Inspector General and Louisville Metro Police Department. I've provided you a copy of this recommendation. I've chosen to do it as a recommendation as opposed to the first MOU that we entered into, which was a negotiation. And I chose to do it that way because virtually everything that's in this MOU comes directly from the consent decree. There are a few additions, and I will highlight them, that differentiate from the consent decree. The first differential is that, like the monitor, we would like direct access to Power DMS, KY Courts, KY Ops, IA Pro, iLeads, Mark 43, all of the electronic databases that the department maintains data on. We would like the same access as the monitor. We outline that in one paragraph. And then the other changes are simply taking the public reporting requirement, which is near the end of the consent decree, and turning that into a specific reporting requirement to the Office of Inspector General. Aside from the obligation to report to us on a bi-monthly basis regarding the civilian complaints, we want to include the requirements that that are listed as the public reporting requirements in the consent decree. But instead of having them be an annual, one of them we have on a monthly basis and the other one we have on a semi-annual basis. And those are essentially related to internal discipline for the department. Other than that, the paragraphs that were taken verbatim from the consent decree. So I would ask that you adopt this for submission to the chief for his adoption by the department.
Have we asked for the access to electronic bases in the past?
We do have access to evidence.com, which is where the body-worn cameras are. And we do have that access. We do have that direct access. I think that, given the consent decree, that will stay in place. This is more access to the case monitoring and things like that.
And the monthly and semi-annual, currently, you get reports annually?
No, these are a brand-new report.
Brand new, and this comes from the consent decree?
Yes,
Okay.
it's a brand-new reporting requirement. It's actually something that we asked for in the very beginning, which Chief Shields said that she would provide to us a monthly update on all the internal, right, and then we didn't get it.
Right.
But it's in the consent decree, and all we're doing is asking that we get it directly and that on a more regular basis than annually for our own data purposes. And then short of that, otherwise then our next avenue of evaluation would be discipline.
Okay, so in the consent decree, the frequency with which the OIG should get reports is what in the consent decree?
In the consent decree, it's not required to give it to us specifically. It's a public reporting requirement.
Okay, all right, and we're asking to get it specifically?
Correct.
Okay, okay, just, okay.
Okay. Any other concerns? Okay. So you have before you the recommended MOU. And having had time to consider it, I move that we adopt the MOU and so that the Inspector General can pass it along, submit it for adoption by the chief. All those in favor, let me know by saying aye. Aye. Okay. Thank you. Tanisha? Can you hear us?
Yes, I'm here. Can you hear me?
Okay. We didn't hear you. I just want to make sure that you're hearing us.
Yes, ma'am. I'm here. I had you all on mute.
Okay. All right. Thank you.
Thank you.
Okay, so investigation recommendations. This is going to change a little bit over time from how we've done it in the last, we've been doing it for a couple of years this way, yeah. But for now, this is what we have. And so first case is 108-IG 2024. The date of the incident is June of 2022. The date of the complaint is September of 2024. The complainant addresses sexual discrimination within LMPD training department. We're recommending no further investigation. The complainant submitted a PSU complaint prior to submitting a complaint with our office. The complainant wishes to withdraw her complaint with our office.
Having had time to consider the recommendation without objection, the motion is on its passage. All those in favor, let me know by saying aye.
Aye.
Okay. Tanisha, if you will unmute so we can hear you, your response.
Yes, could you repeat that second? I'm sorry, on the, repeat
Okay.
what you just said.
On recommendation for 108 IG 2024,
Yes, I'm okay with it.
You want to adopt, okay, thank you.
Yes.
Okay,
Next case is 119IG-2024. The date of the incident is 11/22 of 2024, and the date of the complaint is 11/26 of 2024. Complainant alleged that on November 22nd, 2024, he went to Walmart with another individual, a female. As he was leaving Walmart, he was stopped, detained, and questioned by Walmart's security because the female he was with was caught shoplifting. Complainant was released after the female admitted to shoplifting and informing security that the complainant was not aware that she was stealing. Complainant further alleged that the Walmart security officer was not professional and called him a thief. The evidence reviewed in this matter was a LMPD report and witness interviews. We're recommending no further investigation. The preliminary investigation revealed the complainant believes that Walmart security was a police officer. Complainant did not get the name of the Walmart security officer. OIG staff inquired with LMPD if they kept a master list of LMPD officers working secondary employment, and they do not. There were no calls for service at that Walmart on or around November 22nd of 2024. OIG staff called Walmart over 15 times and went to the location and was unable to make contact with a manager. Made contact once. The manager informed OIG staff that Walmart hires their own security officers, but could not provide the name of the security officer involved in the incident. The manager took OIG staff's contact information and said the security manager would call them back. OIG staff did not receive any return calls from Walmart. OIG staff inquired with PSD or PSU to see if the complainant had filed a PSU complaint. The complainant did file a complaint with PSU. OIG staff learned that the PSU had the same difficulties when contacting Walmart and Walmart providing information. The PSU investigator did make contact with Walmart after several attempts. Walmart informed the PSU investigator that Walmart security was involved in the incident and not an LMPD officer, but would not provide their name. Areas of concern. This case outlines the need for the Office of Inspector General to have subpoena powers. This case also highlights a need for LMPD's secondary employment master list. LMPD should be aware of which officers are working a secondary job, where they are working, and when they are working. Therefore, our OIG staff is recommending no further investigation because it is alleged that the Walmart security officer was involved and not LMPD.
Totally agree with number two, but that it's up to LMPD to decide to create that secondary employment master list, correct? It would be nothing that
Yes.
we would recommend. It's not a policy thing. It could be considered a best practice. Okay. And we've talked about subpoena powers for as long as I've been on this board. If you'd had subpoena powers, what would you have been able to get in this case that you didn't get?
Video
Okay.
from the store without having to work with the staff. We could have circumvented having to work with staff and gotten the video from that particular time frame.
okay. All right, having had time to consider the recommendation for 119 IG 2024, without objection, the motion is on its passage. All those in favor, let it be known by saying aye.
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 Thank you.
Next, we go to 121 IG-2024. The date of the incident was 10/25 of 2024. Date of the complaint was 12/19 of 2024. Complainant attempted to submit a complaint to PSU, but was told she was unable to submit a complaint. I didn't bring the attachment. In this case, we reviewed the body-worn camera, the LMPD reports, and interviewed the complainant. We're recommending no further investigation. And is that yours?
This is, cow. So it's, do you want me to explain it?
Just, like a brief summary to trick my memory again.
She was, living with her parents, and then the officers came, and she said the officers were.
Okay, yes. The officers did appear, and there were, and they did an assessment, and we reviewed it and found that they did act appropriately in this case. So that's why we're recommending no further investigation. That was the review of the body camera and the LMPD reports that we had access to.
Can we have everything sent to us just as a follow-up, though?
Yes.
I mean, because even what was emailed to us doesn't have anything.
Yes.
Just so for our records.
Do you want to?
Like you would normally do, why, just,
Yes.
yeah.
We have time to consider this recommendation 121 IG 2024. Without objection, the motion is on its passage. All those in favor, let it be known by saying aye.
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 Thank you, and we'll get the attachment.
Yes.
Thank you.
Moving to 130 IG-2025. The date of the incident was 9/22 of 2024. Date of the complaint was 2/3 of 2025. On February 3rd, 2025, a civilian complaint was submitted with our office requesting an investigation into why responding officers failed to complete a report following a reported assault. The complaint was assigned the following case number 130 IG 2025, and an investigator the same day it was received. Complainant alleges responding LMPD officers failed to act or investigate an assault due to the alleged assailant stating he was the son of an LMPD officer. Complainant stated following an assault on September 22nd, 2024, outside the Atomic Bar, 1125 Bardstown Road, around 4 a.m., responding officers failed to complete any reporting documentation. Officers also failed to collect statements from individuals who witnessed and were involved in the assault. Following the assault, the complainant and other family members contacted LMPD and were informed there was no report for an assault in question. Family members continued to contact LMPD requesting a report be completed. Complainant's family submitted a cell phone recording of the assault. Once cell phone video was submitted, LMPD, a detective, Kelly Greer, was assigned the case. In this matter, we review the body-worn camera, the LMPD reports, and the CAD report. And we're recommending no further investigation. And I see that I did not send this attachment as well.
We did get the attachments to these. These were in our April, what are we in? They were in our April packet. So I have that attachment if you want to share it.
Thank you.
They're part of the packet that came in April, and we didn't. That goes with the.
Well, as outlined in the complaint and the preliminary investigation, the steps that the investigator took in this case to review the body-worn cameras and to ultimately see that a complaint was taken. We were unable to substantiate any supporting evidence that anyone was related to an LMPD officer. So we're recommending no further investigation.
Having had time to consider recommendation 130 IG 2025, without objection, the motion is on its passage. All those in favor, let it be known by saying aye.
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 Okay, thank you.
Moving to 131 IG-2025, the date of the incident 2/9 of 2025, the date of the complaint 5/22 of 2025. Complainant alleges that on February 9, 2025, she was stopped by a member of LMPD for expired tags while driving in the 2nd Division. The LMPD officer told the complainant that he ran his tags and they came back as expired. Complainant's registration sticker on his license plate was up to date, and the complainant was able to provide valid registration. Prior to releasing the complainant, the LMPD officer told the complainant that sometimes their system is incorrect, but that if he could have seen complainant, he would not have pulled him over. The complainant is an 80-year-old white male. Complainant was driving a Mercedes with tinted windows. Complainant believes that LMPD officer's comments were inappropriate, insinuated that had the officer been able to see that the complainant was an older white male, he would not have pulled him over. We're recommending no further investigation after interviewing the complainant and reading the LMPD reports, because we're recommending that this case be transferred to the PSU unit for an investigation to determine if the officer had a valid reason to stop the complainant and if the officer's comments were within LMPD's policy for courtesy and bias. So we're recommending that we not do the investigation, but that it be submitted to PSU for their investigation, because there may be discipline associated with this particular alleged violation.
Okay. All right, having had time to consider the recommendation for 131 IG 2025, without objection, the motion is on its passage. All those in favor, let it be known by saying aye.
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 Thank you.
Moving on to 132 IG-2025, the date of the incident was 5/17 of 2023. Date of the complaint was 2/11 of 2025. Complainant alleges police are not enforcing no parking zones, and because of this, she was involved in a traffic collision. Complainant alleges riding her motorcycle when she crossed the intersection in which she was struck by an automobile. Complainant alleges the teenager was driving on a learner's permit without a licensed driver. Complainant alleges the police wrote her a citation incorrectly and lists the accident as her fault. Complainant alleged that the police report said that she was driving an automobile, ran a stop sign, and struck the motorcycle. Complainant alleges calling LMPD to get this corrected, but no one would assist her or return her call. In this case, we reviewed LMPD reports and CAD reports, computer-aided dispatch reports, and we're recommending no further investigation. Based upon this, the Louisville Metro Office of Inspector General requested information on 3/4, and we received information on 3/5 of 2025. The traffic file contained a collision summary dated 5/17 of 2023, and the ending note stated the investigation was ongoing. No updated information was given. Summary note stated a traffic citation was issued to the unlicensed driver, but a copy of the citation was not included in the file. The file contained a draft Kentucky Uniform Police Traffic Collision Report. Traffic file contained affidavit for search warrants without any outcome. The Louisville Metro Office of Inspector General recommends Professional Standards Division initiate an investigation into possible administrative violations of SOP, including but not limited to 7.33, investigative responsibility, 8.35, investigative case files. So we're requesting that this case be forwarded to PSU for investigation.
Having had time to consider recommendations for 132 IG 2025, without objection, the motion is on its passage. All those in favor, let it be known by saying aye.
Aye.
Thank you.
Next on our agenda is 136 IG-2025. Date of the incident is 2/17 of 2025. Date of the complaint is 2/25 of 2025. On February 26th, 2025, a civilian complaint was submitted to our office requesting an investigation into a report completed by an officer following a traffic accident. Complainant states the officer noted in the report that the collision was head-on and one of the vehicles lost a tire, causing them to swerve into oncoming traffic and collide with the other vehicle. In this preliminary review, the body-worn camera was reviewed, LMPD reports, and the computer-aided dispatch reports. We're recommending no further investigation. Our office was unable to make any determination regarding the traffic collision and report narrative due to the reporting responding officer failing to activate his body-worn camera. By failing to activate his body-worn camera, there is no evidence recording of the interviews with the involved parties. Our office recommends a PSU investigation into the officer's failure to activate the body-worn camera and the responding officer's failure to arrive on scene.
Can you explain the last part? I understand the camera, a responding officer failure to arrive on scene, but they were there, correct?
I believe that the CAD says that there should have been some other officer there as well.
No, it's secondary.
Yes.
Second officer.
Having had time to consider recommendation 136, IG 2025, without objection, the motion is on its passage. All those in favor, let it be known by saying aye.
Aye.
Thank you.
Next on the agenda is 137 IG-2025. The date of the incident is 4/15 of 2025. And the date of the complaint is 5/20 of 2025. Complainant alleges that she is being harassed and or investigated by someone, but she does not know who. For this incident, we reviewed LMPD reports and interviewed the complainant, and we're recommending no further investigation. Complainant believes that someone is harassing and or investigating her. The complainant could not provide any specific incidents in which she was harassed and or investigated. Complainant has not contacted LMPD about the harassment or potential investigation. Complainant has not had any interactions or complaints against any member of LMPD. Therefore, OIG staff is recommending no further investigation.
Having had time to consider recommendation 137, IG 2025, without objection, the motion is on its passage. All those in favor, let it be known by saying aye.
Aye.
Thank you.
On to 140 IG-2023. Date of the incident is 4/23 of 2025. The date of the complaint is 4/29 of 2025. Complainant is alleging abuse of police authority. Complainant alleges being targeted by LMPD 1st Division officers. Complainant alleges being tightly placed in handcuffs without being read Miranda rights. Complainant alleges having his electronic devices confiscated, Apple phone and watch. Complainant alleges being called a different name by LMPD officers during the arrest. Complainant alleges LMPD officers gave him several reasons why he was under arrest. For this matter, the body-worn camera, the LMPD reports, the computer-aided dispatch reports, and the complainant was interviewed. We're recommending no further investigation. Complaint does not rise to the level of abuse of police authority. Complainant had an active warrant at the time of his arrest. LMPD officers were acting within their SOP 10.1.5 arrests with a warrant. and state law KRS 440.270, which allows law enforcement members to apprehend a wanted person from another state. Complainant was searched incident to arrest. Complainant's wallet and cell phone were confiscated and placed in a property bag. Body-worn camera shows complainant did not allow officers to take his Apple Watch at the time. Officer acknowledged calling the complainant the wrong name by mistake, and that's caught on video at 10/12/12 timestamp.
Right. Having had time to consider recommendation 140, IG 2025, without objection, the motion is on its passage. All those in favor, let it be known by saying aye.
Aye.
Thank you.
Next on the docket, 141 I know we have a lot this month. 141-IG-2025. The date of the incident is 3/25 of 2025. The date of the complaint is 4/29 of 2025. Complaint state LMP officer backed into her car while stopped at a stoplight. Accident report states the complainant hit LMPD officer's vehicle, even though the complainant was stopped at the moment of impact. In this matter, we reviewed the body-worn camera and the LMPD reports. We're recommending no further investigation by OIG. Officers were attempting to follow a suspect when the suspect pulled into a parking lot. The officer driving attempted to parallel park to avoid being noticed by the suspect. While attempting to parallel park, the officer hit the front of the complainant's vehicle. The complainant's vehicle was stopped at the time of the collision. Officer made multiple comments on the body-worn camera, admitting to the accident being their fault. Recommend a PSU investigation into the accident report or a correction of the report narrative to fully and clearly represent the events.
Okay. Having had time to consider recommendation 141, IG 2025, without objection, the motion is on its passage. All those in favor, let it be known by saying aye.
Aye.
Okay, thank you, sir.
142 IG-2025. The date of the incident is 3/21 of 2025. Date of the complaint is 5/21 of 2025. Complaint was filed anonymously and alleged that a hair salon conducts unlicensed practices such as laser and eyebrow tattoos. We're recommending no further investigation because we have no jurisdiction over tattoo and salon parlors.
All right. Having had time to consider recommendation 142, IG 2025, without objection, the motion is on its passage. All those in favor, let it be known by saying aye.
Aye.
Thank you.
Next is 143 IG-2025. Complainant alleges, the date of the incident is 2/1 of 2024. Date of the complaint is 4/29 of 2025. Complainant alleges being harassed by LMPD, quote, every second, every minute of the entire day. Complainant alleges being deported to Mexico and LMPD officers are still making death threats. In this matter, we reviewed the LMPD reports, the computer-aided dispatch reports, interviewed the complainant. We're recommending no further investigation. Preliminary investigation determined complainant's allegations are unfounded. Complainant has not provided any documentation or timeline to support the allegations. Limited LMPD information on the complainant. The complainant has citations originating from LMDC.
Having had time to consider the recommendation for 143 IG 2025, without objection, the motion is on its passage. All those in favor, let it be known by saying aye.
Aye.
Thank you.
And the last investigation recommendation is 144 IG-2025. Date of the incident is 9/20 of 2023. Date of the complaint is 5/12 of 2025. Complainant state LMPD failed to investigate a theft of paperwork from his vehicle. We reviewed LMPD reports and interviewed the complainant. We're recommending no further investigation. The complainant does not present themselves as a credible witness to their own complaint. The complainant was found to be non-compliant and refused to supply investigators with the date of the theft. Our office was able to determine that LMPD detectives have attempted to investigate the theft of the paperwork. However, the complainant has been uncooperative in supplying the detective the information necessary to complete their investigation. Therefore, we recommend no further investigation.
Having had time to consider recommendation 144, IG 2025, without objection, the motion is on its passage. All those in favor, let it be known by saying aye.
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 Thank you. Thank you, Mr. Inspector General. We had a long list today.
That's a lot of work by the investigative staff.
That is a lot of work by the investigators. So thank you all very, very much. Yeah, thank you very much.
And next on the agenda is one case under investigative findings, 87 IG-2024. You've been provided a copy of our final report. This is a case that has been previously investigated by the PSU unit, and the chief has issued a finding. On April 26, 2024, we received a complaint from the complainant alleging abuse of police authority. The complainant reports calling the police due to a shooting outside her apartment in the parking lot. The complainant alleged the police shut the door on her as she was talking with someone outside her door, and alleged being handcuffed and forced to sit outside of her home while the home was searched without a warrant. In our findings report, we detail all of the facts of the case, and then we go through what is the chief's findings exonerating the officers in this particular case. We also detail our interview of the complainant. Essentially, what this boils down to is we have another case of the department believing or finding that the search without the warrant was within policy, under the auspices or under the cover of it being a protective sweep. There was no arrest in this particular situation on scene. There was no one taken from that apartment except for the caller. And what, in our evaluation, it appears that it was clearly retaliation based upon the interaction that the complainant had with this particular, the particular officer that conducted the search. The officer who conducted the search was not the first officer on the scene. The first officer on the scene describes to the other officers on the scene that the perpetrators of this particular action are already gone, and they're there to collect evidence and then do an investigation. Under no circumstances is a protective sweep allowed in that circumstance. If there was to be a search of the residence, there would need to be permission by consent, or there would have to be a warrant. That did not take place here. So we do not concur with the findings of the chief in this particular case. So all we can do is forward, essentially, our recommendation of non-concurrence to the chief for his review.
Thank you, sir. You all have the final report for this investigation, and so we know what will be forwarded to the chief. Okay? Thank you, sir.
So, under other business, we have just a couple of things. There are 3 nominees for the board, which will be going to the Government Oversight and Audit Committee on the 3rd of June. I have their names, but I don't have their contact information, so I have not reached out to them as yet. I will try to do that prior to their meeting with the subcommittee, and I will attend the subcommittee meeting with those nominees. Regarding the board training, once we have all of the positions filled, then the board training will take place so that we don't have to do it over and over again. And that's simply to make it the most convenient for everybody, the attendees, as well as the department. So the department doesn't have to have somebody set up on a Saturday 3 or 4 times. So we want to be respectful of everyone's time. And it was a mutual decision that we reached with the training academy and ourselves. And then the last thing that I want to mention is on the 15th of May, the Supreme Court issued a use of force decision. It's been a long time since the Supreme Court weighed in on use of force by police officers. The case is Barnes v. Felix out of the 5th Circuit in Harris County. And essentially the issue for consideration, or the issue that the court ruled on, was which is the deciding factor for the use of deadly force. Is it the moment of the threat? Is it that theory, or is it the totality of the circumstances? And the Supreme Court, in a 9-0 decision, which there are no unanimous decisions anymore, decided that the totality of the circumstances is what is to be considered for officers in the use of deadly force. The facts in this case are tough. A driver is pulled over for unpaid tolls. It's a rental vehicle, so the driver is not responsible for the tolls associated with that license plate. Somehow during the traffic stop there is confusion as to what should happen or what is going to happen, and when the officer asks the driver to step out of the vehicle, the driver turns on the ignition and begins to drive away. The officer attaches himself to the vehicle and then shoots the driver. Bless you. So the court considered this fact pattern because in the 5th Circuit, the moment of the threat is the theory that is used in the 5th Circuit. But that's not in line with the Supreme Court cases of Tennessee v. Garner and Graham v. Connor, which are the totality of the circumstances. And so the court adopted their standard of totality of the circumstances. The bottom line is, one of the considerations under Garner is the severity of the crime. This was a traffic stop for unpaid tolls. Someone shouldn't lose their life over unpaid tolls. You can argue back and forth about compliance with orders and all of these other things. The underlying severity of the crime was unpaid tolls. What I would have liked the Supreme Court to also rule on, which they did not, was the officer putting themselves in jeopardy in order to use force. They did not rule on that aspect of the case. But the bottom line is that I believe it's a good ruling that officers, even in the use of deadly force, have to consider the totality of the circumstances. And it can't be simply the moment of the threat, which I think is a good outcome for the public. So I just wanted to bring that to your attention. If LMPD has not considered that aspect of their use of force policy, they will have to do that, given this recent change. I don't know if I haven't reviewed their policy for this particular aspect of deadly force, but it will be something that they have to consider. And with that, I have nothing else.
All right. Is there anything else? Anybody? Okay. Then at 4:13, we can consider ourselves adjourned until our next meeting, which is scheduled for June 24th, 2025 at 3 p.m. Okay? Thank you.
Thank you.
Thank you.